Rule 110. Prosecution of Offenses. Section 1. Institution of Criminal Actions. Criminal actions shall be instituted as follows. A. For offenses where a preliminary investigation is required pursuant to Section 1 of Rule 112 by filing the complaint to the proper officer for the purpose of conducting the requisite preliminary investigation. B. For all other offenses, by filing the complaint or information directly with the municipal trial courts and municipal circuit trial courts, or the complaint to the office of the prosecutor. In Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. The institution of the criminal action shall interrupt the running period of prescription of the offense charge unless otherwise provided in special laws. Section 2. The complaint or information. The complaint or information shall be in writing in the name of the people of the Philippines and against all persons who appear to be responsible for the offense involved. Section 3. Complaint defined. Complaint is a sworn written statement charging a person with an offense, subscribed by the offended party, any peace officer or other public officer charged with the enforcement of the law violated. Section 4. Information defined. Information is an accusation in writing charging a person with an offense, subscribed by the prosecutor and filed with the court. Section 5. Who must prosecute criminal actions? All criminal actions commenced by complaint or information shall be prosecuted under the direction and control of the prosecutor. However, in municipal trial courts or municipal circuit trial courts, when the prosecutor assigned thereto or to the case is not available, the offended party, any peace officer or public officer charged with the enforcement of the law violated may prosecute the case. This authority seizes upon actual intervention of the prosecutor or upon elevation of the case to the regional trial court. Section 6. Sufficiency of complaint or information. A complaint or information is sufficient if it states the name of the accused, the designation of the offense given by the statute, the acts or omissions complained of as constituting the offense, the name of the offended party, the approximate date of the commission of the offense, and the place where the offense was committed. When an offense is committed by more than one person, all of them shall be included in the complaint or information. Section 7. Name of the accused. The complaint or information must state the name and surname of the accused or any appellation or nickname by which he has been or is known. If his name cannot be ascertained, he must be described under a fictitious name with the statement that his true name is unknown. Section 8. Designation of the offense. The complaint or information shall state the designation of the offense given by the statute, avert the acts or omissions constituting the offense, and specify its qualifying and aggravating circumstances. If there is no designation of the offense, reference shall be made to the section of or subsection of the statute punishing it. Section 9. Cause of the accusation. The acts or omissions complained of as constituting the offense and the qualifying and aggravating circumstances must be stated in ordinary and concise language and not necessarily in the language used in the statute but in terms sufficient to enable a person of common understanding to know what offense is being charged, as well as its qualifying and aggravating circumstances, and for the court to pronounce judgment. Section 10. Place of commission of the offense. The complaint or information is sufficient if it can be understood from its allegations that the offense was committed or some of the essential ingredients occurred at some place within the jurisdiction of the court, unless the particular place where it has committed constitutes an essential element of the offense or is necessary for its identification. Section 11. Date of commission of the offense. It is not necessary to state in the complaint or information the precise date the offense was committed except when it is a material ingredient of the offense. The offense may be alleged to have been committed on a date as near as possible to the actual date of its commission. Section 12. Name of the offended party. The complaint or information must state the name and surname of the person against whom or against whose property the offense was committed, or any appellation or nickname by which such person has been or is known. If there is no better way of identifying him, he must be described under a fictitious name. A. In offenses against property, if the name of the offended party is unknown, the property must be described with which particularity as to properly identify the offense charge. B. If the true name of the person against whom or against whose properly the offense was committed is thereafter disclosed or ascertained, the court must cause the true name to be inserted in the complaint or information in the record. C. If the offended party is a juridical person, it is sufficient to state its name or any name or designation by which it is known or by which it may be identified, without need of averring that it is a juridical person or that it is organized in accordance with law. Section 13. Duplicity of the offense. A complaint or information must charge but one offense, except when the law prescribes a single punishment for various offenses. Section 14. Amendment or substitution. A complaint or information may be amended in form or in substance without leave of court at any time before the accused enters his plea, after the plea, and during the trial. A formal amendment may only be made with leave of court and when it can be done without causing prejudice to the rights of the accused. Section 15. Place or action is to be instituted. A. Subject to existing laws. The criminal action shall be instituted and tried in the court of the municipality or territory where the offense was committed or where any of its essential ingredients occurred. B. Where an offense is committed in a train, aircraft, or other public or private vehicle while in the course of its trip, the criminal action shall be instituted and tried in the court of any municipality or territory where such train, aircraft, or other vehicle passed during such its trip, including the place of its departure and arrival. C. Where an offense is committed on board a vessel in the course of its voyage, the criminal action shall be instituted and tried in the court of the first port of entry or of any municipality or territory where the vessel passed during such voyage, subject to the generally accepted principles of international law. D. Crimes committed outside the Philippines but punishable under Article 2 of the Revised Penal Code shall be cognizable by the court where the criminal action is first held. Section 16. Intervention of the offended party in criminal action, where the civil action for recovery of civil liability is instituted in the criminal action pursuant to Rule 111, the offended party may intervene by counsel in the prosecution of the offense. Rule 111, Prosecution of Civil Action. Section 1, Institution of Criminal and Civil Actions. A. When a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charged shall be deemed instituted with the criminal action unless the offended party waives the civil action, reserves the right to institute it separately, or institutes the civil action prior to the criminal action. B. The criminal action for violation of Batas Pambansa BLG 22 shall be deemed to include the corresponding civil action. No reservation to file such civil action separately shall be allowed. Section 2. When separate civil action is suspended after the criminal action has been commenced, the separate civil action arising therefrom cannot be instituted until final judgment has been entered in the criminal action. Section 3. When civil action may proceed independently in the cases provided for in Articles 32, 33, 34, and 2176 of the Civil Code of the Philippines, the independent civil action may be brought by the offended party. It shall proceed independently of the criminal action and shall require only a preponderance of evidence. In no case, however, may the offended party recover damages twice for the same act or omission charged in the criminal action. Section 4. Effect of death on civil actions. The death of the accused after arraignment and during the pendency of the criminal action shall extinguish the civil liability arising from the delay. However, the independent civil action instituted under Section 3 of this rule, or which thereafter is instituted to enforce liability arising from other sources of obligation, may be continued against the state or legal representative of the accused after proper substitution, or against said state as the case may be. The heirs of the accused may be substituted for the deceased without requiring the appointment of an executor or administrator, and the court may appoint a guardian and ad litem for the minor heirs. Section 5. Judgment in civil action not a bar. A final judgment rendered in a civil action absolving the defendant from civil liability is not a bar to a criminal action against the defendant for the same act or omission subject of the civil action. Section 6. Suspension by reason of prejudicial question. A petition for suspension of the criminal action based upon the pendency of a prejudicial question in a civil action may be filed in the office of the prosecutor or the court conducting the preliminary investigation. When the criminal action has been filed in court for trial, the petition to suspend shall be filed in the same criminal action at any time before the Prosecution res. Section 7. Elements of prejudicial question. The elements of a prejudicial questions are: A. The previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action. And B. The resolution of such issue determines whether or not the criminal action may proceed.